Welcome. My name is David Miller, and I'm a partner with the law firm of McCullough and Miller. At McCullough and Miller, we focus on probate, estate planning, and elder law. And I'm here today to talk a little bit about probate and specifically what types of assets have to go through the probate process and some of the dangers with some of the typical probate avoidance techniques that you might be familiar with. So I want to talk a little bit about first what types of assets go through probate. I want to talk about some of the common probate avoidance techniques that are out there. I want to talk about some of the issues to look out for and then give you some real world examples of what can go wrong with using those types of probate avoidance techniques. And finally, I want to talk about some of the ways to avoid those mistakes and some of the alternatives that are out there. So first, what goes through probate? Well, the smart aleck response is, well, your estate goes through probate. So then the question is, what's in your estate? Okay. So some of the common things that might be in your estate, the things that people think about are maybe real property, financial accounts like bank accounts, checking accounts, brokerage accounts that are titled to you. But there's some other ones that you might not necessarily think of. So for instance, notes, money that people owe you under some sort of promissory note or other type of contract. Well, that contractual right belongs to your estate. The personal property, the things that you own, your furniture, your clothes, artwork, personal effects, family heirlooms, jewelry, those actually are owned by your estate. Then there are LLC interests. A number of my clients have LLCs either because they own and operate their own business for a living, or maybe they have something like a rental property that's set up as an LLC. If those LLC interests, and importantly, the bank accounts that are set up with those are owned by your estate. And so I'll give a quick example here. I do have a client who his father passed away. His father ran a fairly large LLC, and that LLC had employees and vendors and bank accounts set up to pay those vendors and pay those employees, and he passed away. And what happens there is the bank froze the LLC accounts. And so now all of a sudden, that person cannot pay their employees, they cannot pay their vendors. And that's something to think about when you're talking about what assets do I own? What are the types of things that are gonna get jammed up in the probate process after I pass away? And that might actually affect the value of my estate for my beneficiaries. Other things, lawsuits. A lawsuit is going to be owned by your estate. So imagine a situation where you pass away because you're hit by an 18-wheeler. And you pass away, and now all of a sudden you have a wrongful death lawsuit against that 18-wheeler company. Well, that's going to be owned by your estate. And then that lawsuit will actually have to be subject to the probate process. Inheritance that might be coming to you. You might be the beneficiary of your long-lost uncle's will, right? And if he passes away and that inheritance is coming to you, and then you pass away, or maybe you passed away before he did, but his will was such that it goes to you alone, then that inheritance is coming to your estate and can only be given to your beneficiaries through the probate process. Right, so there's a lot of different types of assets that have to go through the probate process, and some of them are just not so obvious. Now, I would like to also talk about common probate avoidance techniques, right? So these are things that you are probably familiar or maybe heard of, and there's the big one. So like the big one is beneficiary designations, right? So a beneficiary designation would be something like naming someone as the beneficiary of life insurance proceeds, or as the beneficiary of an IRA or 401k, or maybe having a transfer on death designation on some sort of bank account or brokerage account. Joint ownership is another big one. This is where, for instance, my wife and I, we have a checking account, and we're both joint account owners. The account's what we call a JTWROS, or Joint Tenants with Rights of Survivorship. That's legal speak for we both own that account, right? We both have the ability to withdraw or deposit from that account, and then upon the passing of one of us, the other is already the full owner. So that does not have to go through the probate process. Transfer on death deeds for real estate. There are kind of simple transfer on death deeds, or kind of a more nuanced ladybird deed. This is a deed that you sign while you're alive to give your property to somebody else upon your passing, right? And by doing that, you do not have to probate that property. It's automatic. And then gifts, outright gifts, just saying, hey, I'm not going to go through the probate process. I'm going to write a check to you today while I'm alive, or deed this property to you while I'm alive. And so the common question that I get is, do these probate avoidance techniques work? And the answer is yes, they do, sometimes. In fact, these probate avoidance techniques are very powerful tools, and there is something that is going to be used in your estate plan kind of no matter what. We use these types of techniques every day, but they have to be used correctly. And if they're not used correctly, or they're not thought about what the impact of using these tools are, it could very easily derail your estate plan and could cause other issues for you or your beneficiaries down the road. So what can go wrong with these, right? It's simple. If it's contractual, it goes to my beneficiaries. What could possibly go wrong with that? Well, there's a couple different problems. So first of all, if you use beneficiary designations and you're relying on that, you understand that sometimes banks and financial institutions lose paperwork. This is something that I've seen repeatedly. I actually used to work at a bank, and I've been involved with lost paperwork. So it does happen. It's not often, but when it does happen, what is your recourse? How are you going to deal with that? It can become an issue. And the issue most likely is you're back to probate. The beneficiaries might inherit that property or those accounts, but if you are trying to look at avoiding probate across multiple generations or multiple passings of this property, once they inherit those IRAs, if they don't update the beneficiary designations on the new account, the new inherited account, that's going to have to be probated then. The designations might conflict with your will plan, and we'll give some examples of this, but you have to make sure that your IRA or 401k beneficiary designations act in concert with your will and the rest of your distribution plan. Another common type is joint ownership, and joint ownership can be great because, again, once you pass away, the joint owner is automatically the owner of that account. So some of my clients will have maybe, say, a child or a trusted agent as their joint owner so that they can use that account, access that account, manage that account, and then upon my client's passing, their daughter or trusted agent is automatically the owner and avoids probate. But the problem here is by doing joint ownership, you're exposed to that joint owner. If that joint owner has debts, the creditors can theoretically seize upon that account. If that joint owner is a bad actor, they're going to have broad discretion and wide ability to do bad things with your money. And finally, again, joint ownership can conflict with your overall distribution plan if it's not properly thought out. Transfer on death deeds, again, a very common tool that we use. But if you do a transfer on death deed to your children for, say, a piece of property, you have some issues associated with that. One, you might inadvertently be putting your children or the grantees of that transfer on death deed in business together. And that might not be great. And I'll give it a little example of how this might play out. But ultimately, it can end in conflict between your children and whoever's inheriting that property. And also, every time your distribution plan changes, you have to go through the process of redeeding that property. And finally, gifts is another one, right? Well, the problem with gifts is, yes, you avoid probate, but you lose control over that asset in its entirety. It is now completely in the control of the giftee. And by doing that, that gift is now exposed to predators out there, scammers, predators, spouses, and basically you're really relinquishing control and putting that money at risk. So I want to walk through a couple of real world examples of how that plays out and kind of give you a sense of what happens if it does conflict with your distribution plan, okay? So first I want to talk about a simple but common scenario where you have beneficiary designations on accounts and somebody might have diminished capacity when they inherit that money. So imagine a situation where you have mom and dad, and really they want to avoid the probate process. Okay, so what do? Well, they have an IRA and they have a joint checking account. And so to avoid the probate, they put each other as the beneficiary on their IRAs, and they're already joint owners on the checking accounts. They don't have to worry about ownership when one spouse passes away. Now imagine if dad passes away, and when he does, mom is 85, and now she is living alone, right? Because of what they did, well, they avoid probate for dad. Mom automatically inherits an IRA, and she's already a joint owner on the checking account. So probate's avoided. Great. So what's the problem here? Okay, well, mom is 85, and she might be a couple of steps behind where she used to be and has some level of diminished capacity, and she's living alone. And when all this happens, she forgets to update the beneficiary designations on her new inherited IRA, being the IRA that she inherited from her husband. She also forgets to put a beneficiary designation on the joint checking account. And then what might happen? Well, one day maybe she takes a phone call from a stranger, and that stranger says, "Hey, I represent the IRS. You owe $25,000 in back taxes, and if you don't wire the funds to us immediately, we have to send a sheriff out to arrest you." Now, you and I, and most people will probably recognize this as some sort of scam, because it's a very common scam, but it's common because it works, especially with someone who has maybe is elderly or maybe has diminished capacity, because they hear taxes, they hear sheriff, they think arrest, they think embarrassment, and what do? They wire the funds out. And so now what's your situation? Well, mom's lost $25,000 to a scam because there was no one there to look after her and make sure that someone was minding the store with respect to these accounts. Also, because she never put the beneficiary designations on, when she passes away, all of these accounts now have to go through probate. So the conclusion here is the money was at risk when dad passed away. And even though their goal was to avoid probate, they did avoid it for dad, but they have not avoided it for mom. So another very common situation that we run into relates to a joint account ownership. That is where a mom has named a child as a joint account owner for ease of use, for administrative purposes, right? And so consider a scenario where mom, say, has 3 daughters, right? Susie, Beth, and Megan. And Susie lives with mom in mom's house, and she takes care of mom, right? That's kind of the deal. You live here, and then Susie will take care of you. And, you know, Beth and Megan, they don't live in the same city. They don't even live in the same state. They're kind of far away, right? And so for simplicity's sake, mom puts Susie as the joint account owner on a $100,000 checking account. That way, Susie can access that money whenever she needs to for mom's care. She can use it to buy groceries, she can use it to pay doctors and buy prescriptions, and it just makes it a lot easier. All right, now, what else does mom have? Well, let's say mom has a $100,000 IRA, and she has a house that's worth about $250,000. So her total estate, as she sees it, is worth $450,000. And what she wants to happen when she passes away is that all daughters are treated equally. So what does she do? She puts a beneficiary designation on both the IRA and her checking account to say that each of her daughters inherit a third, a third, a third, and then she has a will that says each of my children inherit equally. So what's the problem with that? Well, the problem is once Susie is put as a joint account owner, she owns that account, just as the same rights as mom does. And so when mom passes away, that account doesn't go through probate, it goes directly to Susie, all right? And what happens is mommy wanted each daughter to inherit equally, right? And there's $450,000 estate, there's 3 children, so they're each supposed to get about $150,000. But what actually is gonna happen is Beth and Megan are gonna get a third of the IRA, and when they sell the house, they'll each get a third of that, but the joint checking account is already owned by Susie. So at the end of the day, Beth and Megan are gonna get $116,000 in change, and Susie's gonna get $216,000, okay? And the conclusion is, mom's wishes weren't actually followed, and now the sisters are all mad at each other. And I can tell you how this conversation goes, because it's happened. After mom passes, the 3 daughters come in my office, and they say, oh, we miss mom so much, we just want to split everything equally, we know what mom wanted. And then we're compelled to tell Susie, well, that's fine, but you're a joint account owner of this account. It doesn't go through probate, you already own that $100,000. And Susie says, oh, I don't care about that. I know we're supposed to split everything equally 3 ways. Then the next day, Susie calls our firm and says, just want to be clear. You mean I actually own that account? That's separate than her estate? We say, yes, that's true. The next day, Susie calls us up and says, you know what? Beth and Megan, they never took care of mom. They never even visited her except on Christmas. I did all the hard work, and Beth and Megan were never nice to mom anyway, and that's when all the dirty laundry comes up, that's when all the hurt feelings come up, and now Susie's gonna keep that extra $100,000 and everyone's mad at each other, right? This is when we talk about estate planning. We wanna think about how things are gonna work and how it's gonna affect everybody kind of from an emotional standpoint. Now, let's talk about another way of avoiding probate, which is transfer on death deeds. Again, a very common situation. Mom and dad have a lake house, and they want to avoid probate. So what do? They name their 3 daughters as the grantees of a transfer on death deed, so that upon the passing of mom and dad, the daughters already own each a third of that property. Doesn't have to go through probate. So that's great. Let's consider a kind of common scenario. Again, you have Susie, Beth, and Megan. Susie lives in Austin, and she's got a big family with lots of young kids, and it's only an hour away from the lake house. Then you've got Beth, who maybe lives in Dallas with her husband. She had one child, but that child's grown up and actually lives in California. And then you got Megan, who actually lives in South Carolina, and she's about to start her new business. So what's the problem here? Well, the problem here is that Susie and her family are going to be able to use that lake house almost every weekend, and it's great for them. They love it. Beth, well, they live like 5 hours away, and they're not necessarily going to be able to use that house more than a couple times a year. And then you got Megan in South Carolina, and she's never going to be able to use that house because she lives in South Carolina. Oh, and by the way, she's starting that business and she needs money now. And what's Susie want? Well, Susie says, hey, we all own a third of this house. We should each contribute to the taxes equally, the insurance and the upkeep equally. Beth says, well, I don't really care if we keep this house or sell this house. It's kind of nice to have, but I'm not going to be in charge of any amount for taxes and insurance and upkeep. And then there's Megan there that says, I can never use this house and I need the money now. We need to sell this house. All right? Well, who's going to win that argument? And so what's the conclusion is? The kids, they're not on equal footing. And again, you have family disharmony, right? The kids, you have avoided probate, but now you've created a fight between your children. Gifting. Another common way of avoiding probate is just to gift the money today. All right, and so let's consider another situation, right? You have mom, she's a widow, and she knows that as she ages, she might need some sort of skilled nursing. And she's worried about paying for that skilled nursing because she doesn't have enough money to pay for it. She wants her daughter to be able to get something when she passes away, and she wants to be able to qualify for public benefits when she needs it. So what does she do? She wants to give $200,000 as a gift to her daughter today. And this will do a bunch of great things, right? Daughter's starting a new business, it might help her out a little bit. It's going to transfer the money today, so if she needs to apply for public benefits, say in 6 or 7 years, it's outside what we call the look back period. And it's also going to avoid probate. And what daughter says is, Mom, don't worry. I'm going to take good care of this money for you. I'm going to be conservative. I'm going to make sure it's always there for your care. And now you've got a situation where mom can qualify for public benefits. There's money that daughter is managing to take care of mom with, and you don't have to probate this money at all. So here's the problem. The problem is Susie, daughter, has a business. And to get that business going, she took some loans from the bank and did a personal guarantee on those loans. And then the business fails. Well, what's going to happen? That $200,000 that mom gifted Susie is now exposed to collections from the bank. And once the bank gets that money, there's no more money for mom's care or for mom's quality of life. And so what happens with gifting, you lose control of it. The money's at risk. It's at risk to the creditors. And when that money goes away, there's nothing in reserve for mom's care. Oh, and by the way, under this scenario, the bank wins. And so that's a couple of really basic examples of what can go wrong with these tools that look on their face like they're going to help you avoid probate. But when you kind of really dig down into the order of operations and how they actually work, they can really derail your estate plan and your overall distribution plan for what happens when you pass away. So what can be done, right? Am I saying don't use these? No, absolutely not. These are very good tools. But what you need to do is, on a very regular basis, you need to revisit your beneficiary designation. And you need to make sure that they still make sense, that they're still applicable. You need to have copies of all the documents so that you can prove it's there in case the bank loses the paperwork. You want to use secondary beneficiaries to make sure that if your primary beneficiary passes away, there's still somebody that's going to inherit and doesn't have to go through the probate process. When you're deeding property to people, like the transfer on death deed, again, we do that all the time, but you want to make sure that up front there is some sort of agreement between everybody involved that's going to have some sort of dispute resolution mechanism or somebody that's in charge. And finally, you want to review your paperwork with an attorney on a regular basis. Attorneys, especially estate planning attorneys, are trained to see where there might be a gap, where there might be a conflict, or there might be an issue, and can walk you through the different ways of how to deal with that issue or that conflict. An alternative to these types of probate avoidance techniques is the use of trusts, right? Now, a trust is a vehicle that you use where you put your assets in that trust today, and then upon your passing, the trust acts as the rule book as to who gets what happens to that trust property. And so in this case, you have one document, one instruction booklet that controls all of your estate and all of your assets. It's going to avoid probate because once a trust owns something, it's not a part of your estate, it's part of trust property and automatically transfers to the beneficiaries of the trust after you pass away. It can protect your assets from public benefits, and you get to write the rules however you want. Whatever you want to happen when you pass away, you can write that into the trust. And by doing that, you can ensure that your wishes are enforced after you pass away. And so that is all I have today. Thank you very much for listening and for attending. If you have any questions about this, please schedule a consult with our law firm, and we can go in a lot more detail about your specific situation and how you want your estate plan to work. Thank you very much. Bye-bye.